We have breaking news from the Supreme Court that could have major implications for future ICE raids in the city of Los Angeles. I want to bring in NBC's Gary Grumbach and back with us, MSNBC legal correspondent Lisa Rubin. Gary, what can you tell us about this ruling?
So the Supreme Court is reversing an order that prevented federal law enforcement from conducting stops in 7 California counties without reasonable suspicion. This was one of those emergency docket cases that just came together in the past few weeks, and it was a 6-3 decision. But the 6 conservatives on this court did not provide a full opinion of the case. It was just Justice Kavanaugh with his thoughts in a concurring opinion on this, saying in part, of course, reasonable suspicion is important and it's necessary, but because there's a large population of undocumented immigrants in the Los Angeles area, because they don't speak English, and because perhaps they all gather in the same areas every day looking for that daily work as day laborers, that in itself is enough reasonable suspicion to stop someone here. So Justice Sonia Sotomayor, in her dissent, along with the 3 other liberal justices, said, quote, "It was a grave misuse of our emergency docket. We should not have to live in a country where the government can seize anyone who looks Latino, speaks Spanish, and appears to work a low-wage job rather than stand idly by while our constitutional freedoms are lost. I dissent." So, Chris, the Supreme Court today effectively okaying racial profiling in immigration enforcement. Chris.
Thank you so much for that, Gary Grumbach. So let me ask the basic question for starters. Does this apply only to those 7 California counties? And is it the final decision on all of this?
Well, first of all, it's not the final decision, but let me go back to your first question. Does it apply only to those 7 California counties? The original order issued by a district court in California did apply only to those 7 counties and restrict immigration officials' ability to arrest people on reasonable suspicion there. The Trump administration, therefore, will feel empowered by today's pause by the Supreme Court. I say pause because it is not the final ruling. However, the breakdown of votes here appears to give some signal into how the court will ultimately vote when this comes back to it. And of course, Justice Kavanaugh saying in his concurring opinion, as Gary just laid out for you, that he doubts that there was any constitutional infirmity with respect to the rounding up of day laborers who don't speak English and who gather in particular places where they are known to look for work. That, to him, does constitute reasonable suspicion and therefore would not be unconstitutional. We can expect this to come back to the court in one way or another. But in the meantime, you can also expect the Trump administration to feel a little bit more free to go on these sort of immigration hunts for undocumented immigrants, not only in Los Angeles, Chris, but in many other areas of the country.
Are we just seeing a lot more use of this emergency docket, shadow docket, than we've seen before?
Yes, and I'm going to give you some statistics, at least from what I can gather on such short notice. We have seen at least 24 applications so far by the Trump administration itself in the first 32 weeks of his presidency. And I just want to give our viewers some context for how that compares to prior presidents. 19 applications were made by President Biden's administration in the entire 4 years that Joe Biden was president. So already in this term of President Trump's presidency, he has exceeded what Biden did in terms of asking the court for emergency relief by a number of 5, right?
So does that mean they're redefining what constitutes an emergency?
Absolutely. And the court is sort of pushing back and saying, this really isn't our emergency docket, or don't call it a shadow docket. They are bristling at that, in part because of some of the criticisms that lower court judges have shared with NBC News' Lawrence Hurley. They are very frustrated with the use of the shadow docket, in part because it doesn't give them sufficient guidance for their own rulings. Shadow docket rulings are by and large non-precedential, and where there is no majority decision laying out the majority's reasoning, all that they can gather is little crumbs here and there, either from a single paragraph on behalf of the majority or what they can glean from a dissent or concurring opinion. That doesn't give lower court judges, whether at the federal appeals court level or at the district court level, where these cases are largely decided, the guidance that they need to make decisions sort of that respect the Supreme Court. And already you've seen Justices Gorsuch and Kavanaugh almost kind of bench slap a lower court judge that they found was insufficiently respectful of their ruling. That judge said that in 47 years, no higher court judge has ever questioned his fidelity to the law, or at least his attempt to do the right thing and be faithful to higher courts above him, but that he doesn't always understand what these justices mean to do when they're ruling on the shadow docket, Chris.
Lisa Rubin, thank you so much.